That's basically what Anthropic is arguing in these cases. That's what all these AI models are arguing, is they're creating something that is so different, it's transformative.
Right. So I can't reprint Harry Potter, but but if I write Wary Potter and the Tale of the Cautious Wizard, maybe, who knows? J.K. Rowling, don't come after me.
He hasn't written it yet. Yeah.
Ever wonder what really happens when your rights are violated and what you can do about it? Ever wonder what the law looks like outside of TV dramas and headlines? Meet Quinn Mayberry, a Harvard-trained trial lawyer who has helped individuals recover millions of dollars, and Alex Lobert, Quinn's lifelong friend and your law translator-in-chief, here to make the law make sense. On this show, they cover headline-making legal battles and overlooked cases to show you how to fight back and win. This is Legally Curious.
Quinn, hello, and welcome to another episode of Legally Curious.
Alex, good to see you. I'm excited for today's episode.
We have a really good one and a topical one because we're going to talk about AI and copyright infringement.
Yeah, I mean, we're talking about the biggest copyright infringement case in U.S. history and a fact pattern that could change the entire industry.
Right. I mean, AI is all the rage. I've actually heard that it might be like powering essentially the U.S. economy at this moment in time. So you're right. I think this is a really important thing to understand for not only people curious about the law, but also people curious about where technology is going.
Yeah,
so,
100%.
All right, Quinn. So we're going to talk about Bartz v. Anthropic.
Before we do, let's talk about the parties at play here. So we've got a few named plaintiffs who are representing this entire class of similarly situated authors. And then we've got Anthropic. So for the plaintiffs, we've got some of these authors who've committed their lives to journalism and creating authorship, writing these books, And I don't think it's a coincidence that the plaintiffs' attorneys chose some of these people, right? It's like we've got Kirk Wallace Johnson, who has spent years, maybe decades, writing about theft and injustice. He's also started a nonprofit for like Iraqi refugees who were, allies to the U.S. government during the war. Some really sympathetic figures. And then on the other side, we've got Anthropic. If you want to tell us a little bit about them, Alex.
So Anthropic is one of the largest AI companies in the world. They're actually a public benefit corporation. So they're supposed to be the good guys of AI.
Yeah. I think they put themselves out there as like the ethical AI company too, and kind of known as that in the industry is my understanding.
They're actually founded by a couple people that left OpenAI because they were not so happy with this direction. But Anthropic has actually grown to be, again, one of the largest AI labs. They have a product called Claude, which is used by about 19 million people worldwide. This is not a small company. They're looking like they're going to make around $5 billion in revenue today, and they have over $100 billion valuation.
Oh my God.
This is a monstrous company that has grown incredibly fast.
Yeah. I mean, I've used Claude before. I knew they were a big company, but I didn't realize that they were, they're up there with OpenAI in terms of scale.
Yeah. Actually, one funny thing, because I think it ties into our conversation, most people actually believe that their product Claude is probably the best at writing.
Nice.
Just think about that. All right. All right.
I wonder where that came from.
I know. It's almost like they got a little help.
Do you think Kirk Wallace Johnson and maybe another one of our named plaintiffs, Andrea Bartz, had something to do with that?
Just maybe. Claude was very busy using their library card.
Yeah.
But in any case, and maybe
if only.
And a couple extra.
Yeah.
If only a couple extra sources. So really, I think this is a case about fair use and whether AI training on your on authors' material is legal or not. And so that's the question at hand. And it really brought us to this, monumental court case.
We've got a really interesting wrinkle here where we've got the question of whether or not training on people's authorship is a transformative fair use. But then we also have this question about, the legal requirements around how they got access to that information in the first place. And that, what seems like a technicality at first leads to some really salacious details in this case. And it is kind of the heart of Anthropic's liability here.
All right, Quinn, do you want to lay out some of the facts of the case and what happened in Bartz v. Anthropic?
Yeah, absolutely. So, all right, the plaintiffs are bringing a class action, which means that they're bringing a claim on behalf of a bunch of people who are similarly situated. In this case, there are roughly 500,000 authors that are being represented by the class. And the claim is that Anthropic stole access to something like 7 million books, or they maintain this library of, millions and millions of books. And they think that the way that they used those books to train their algorithm was illegal. Now, one of the interesting parts of this case, and this is often true in lawsuits, the plaintiffs don't know exactly what Anthropic did, right? It's like they don't have somebody on the inside. This stuff is happening behind closed doors. Some of it is, trade secrets, even how they go about training their algorithms and storing their libraries. But they have this hunch that Claude is using a ton of authors' works. They're not sure how they're getting them. They're not sure how they're using them, but they know the authors aren't getting paid for it. At least a lot of them aren't getting paid for it. And so what's at stake here is if they are infringing these authors' copyrights, intentionally infringing, they could be responsible for statutory damages of at least $750 per infringement and up to something like $150,000 per work. So, I mean, you can do some quick math, and if it really is if they hit for $150K for 500,000 works, I mean, we're somewhere in the range of $100 billion, right?
Starts to look like real money even for an AI company.
Yeah.
Quinn, can you actually, I think one thing that'd be important to quickly dive into is, can you just tell us what a copyright is?
That's a great question. A copyright it's a federal property right given to the creators of original work. The significance is that gives them the exclusive right to control its reproduction, distribution, adaptation, basically control what happens to that work in the future. And there are some exceptions to this, and the biggest is fair use. Basically, if you're using it for purely educational purposes, or you have a really transformative product. So, you, Alex, are an author who has read other books and then go and write a book. It's going to be probably loosely based on some of those other things you've read in the past, but are you using the same words or the exact same ideas, or are you using some essence of this thing that you've read in the past and you're creating something fundamentally different? And if you are making something fundamentally different, that's a transformative use. And that's basically what Anthropic is arguing in these cases. That's what all these AI models are arguing is, they're creating something that is so different. It's transformative. They're training these algorithms in the same way, almost like a person would, train themselves on prior readings, basically.
Right. So I can't reprint Harry Potter. But, but if I write Wary Potter and, the Tale of the Cautious Wizard, maybe, who knows? J.K. Rowling, don't come after me.
He hasn't written it yet.
Have not written it yet. Just workshopping ideas. But okay, fundamentally, you have a copyright if you create an original work and you basically own it.
Yeah, exactly. You've got an original work, and then smart to register it. You might have legal protections, mind you, even if you don't, but it's going to be much harder to enforce those protections, which we'll see later becomes like a really significant issue in a lot of these IP lawsuits. So might have some legal protection, even if you don't register it, always better to register.
So Anthropic is allegedly pirated a number of authors' works.
Yeah.
What's their defense? What do they say?
Yeah, so they start by saying this is transformative fair use. So let's not even worry about that first question we were talking about earlier on. Can they use this material? They say absolutely. And the court basically agrees with them on that point. They can. This is a transformative fair use. So you can use this other authorship to train an AI model. I think this is going to continue to be litigated. I think there's a really good chance that the legislature is going to need to address this issue and put rules around, what do we think is too much? What allows for appropriate innovation, et cetera, et cetera. But for now, the court decides in this case, fair use. The problem and where things get kind of crazy is how they got access to the information. So in discovery, they had this hunch that we were talking about that, Anthropic was using their copyrighted material without their permission. And it turns out they were right. They had these libraries with millions and millions of books that they had pirated. So we're talking something like, it's effectively like LimeWire. They went and pulled these books, they created a file, and then they organized these libraries and trained their algorithms on those libraries of pirated books, allegedly.
And for those that don't know LimeWire, old school music streaming, music pirating service.
Illegal pirating service, yeah.
Illegal music pirating service.
Yeah.
And by the way, who would have thought, not a terrible guess, some Silicon Valley companies skirting copyright. It's it's a tale as old as time in terms of innovation. So in any case, yeah.
Yeah. It's almost like this is part of their playbook. They pirate all these books, they use it to train their algorithm, and they don't really have a good argument for, how they got access to the books. They just said, it's fine that we use them to train. There's some documentation suggesting they said it would be too expensive and time consuming to get the books another way. It's like, oh, you mean paying the authors to license the book?
What an incredible defense. It would be really inconvenient to pay these people for the book.
Yeah.
Okay. Anyways.
Now, in terms of the legal procedure, where they're going to make a lot of the arguments is around trying to prevent the class action and the class in that class action from being certified. So the court certifies a class action or refuses to certify a class action. And to have a class action certified, you have to meet all of these requirements. You have to have sufficient numerosity. The claims within the class need to be sufficiently similar. You need to have an appropriate class representative whose claims are, similar enough to the class to fairly advocate on their behalf. All of these legal requirements. And it can be challenging to get a class certified. And so Anthropic is going to make a bunch of technical arguments around why this class shouldn't be certified, but ultimately it is. So the judge certifies the class, And then in class action cases, this is typically where settlement conversations start getting really serious, because you've got a viable claim, the class has been certified, there are these significant, procedural hurdles you have to jump through. Those have now been met, and basically this is going to go to trial, and people can appropriately assess like their position. And so people start settling.
So once the class is certified, as you said, these kind of cases often move to settlement. But what actually happens? How do we move from this to the largest copyright settlement in history?
Yeah, so this part is maybe more simple than you'd think. Basically, the attorneys start talking. People understand the leverage. In this case, the plaintiffs, they've got a credible argument that this was willful copyright infringement by pirating these enormous libraries of authorship. And for each one of those violations, again, this could be something up to $150K in damages. And then Anthropic on the other side is going to argue, well, it's not actually going to go for that much. Plus, we can only pay so much anyways. Even if you got this verdict, at a certain point, it would just bankrupt us and we wouldn't be able to pay it. So they land on this number that is kind of meeting in the middle to both get a really strong outcome for the plaintiffs, but also an outcome that, is small enough that Anthropic can actually pay it.
Actually, I think it's a really interesting dynamic. So as you said, it's just kind of the lawyers negotiating at this point.
Yeah.
And you're looking for a number that the business can pay, and not actually, if it's too much money, if it's if it's $100 billion, Anthropic just couldn't actually pay it.
Yeah.
And so fresh off a new funding round, 1.5 billion seemed like a number they could actually give to the authors.
Yeah. And that they could pay out for their meritorious claims.
Quinn, I think really, really interesting. And you touched on this earlier, but okay, there were 7 million pirated works, but only 500,000 roughly claimants. What's the delta there? Yeah.
So you had to meet certain requirements to be part of the class. And there were a number of requirements. Maybe some of those books were like legally acquired, or they were already like open source, or for one reason or another, they weren't protected material. And again, there were a handful of requirements, but the biggest one is you had to have your copyright registered. So to be part of the class, you've got to be really similarly situated. And sometimes the classes will break up into different categories of class members, but in this class, you had to have your copyright registered. And so if you didn't have your copyright registered, again, it doesn't mean that you necessarily don't have any legal recourse, but it's harder to enforce, and you're not going to be part of this class. And so not all the authors, some of the work probably not protected, and then a bunch of people didn't meet the class requirements for one reason or another.
The other thing I found really interesting about this settlement was that Anthropic didn't have to agree to any wrongdoing. Didn't have to admit any wrongdoing.
So that's pretty common. I think, so what's going on is, one, they don't want to admit any wrongdoing, right? No company does, and they're this public benefit company. They want to try and, they're going to have a talking point with the media that they didn't admit any wrongdoing. Does that really confuse anybody? I don't think so. Like, it's publicly available information that they pirated all these books. I think, anybody who's bothering to look into this ever so slightly knows that they did some things that were wrong. But where it's most relevant probably is their legal liability. If they've admitted wrongdoing, that could potentially be introduced as evidence in future lawsuits. And so it's a, meaningful difference for them.
Got it. So there is some legal benefit, even if there's negligible marketing benefit. The marketer in me agrees with you. It's like that's not going to really pass a sniff test. We paid $1.5 billion, but we didn't do anything wrong. It's
And so like the legal benefit is also probably not huge, but you're like, in the plaintiffs now have access to all this information that came out in discovery on these terabytes and terabytes of data that they kept in these libraries and that they kept illegally. And so if that becomes a contested point in the future, it doesn't really matter if they admitted wrongdoing or not. You've got, you have that evidence, but then do you have to jump through another hurdle of like proving that was actually improper, yada, yada, yada. I guess all that to say, I don't know how consequential it is on the legal side either, but it's worth something, right? And whenever you're getting paid $1.5 billion, you're going to make some of these concessions to close the deal.
And so that the $1.5 billion settlement ended up being, for the 500,000 books, roughly $3,000 per book.
Yep.
Now, Quinn, can you touch on one thing briefly? Would an author actually see $3,000, or how does it play out? Because I feel like there's usually some discrepancy between the headline number and what the authors will get.
Yeah, so they're not going to get all of it. They will most likely get a very substantial portion of it. There are fees associated with managing the class action. You've got the attorney's fees, but you also have just like, you have to reach out to 500,000 people and set up a bank account and send out checks and give appropriate notice to let them opt out of the class action, or do they have to opt in? There are all of these technical requirements that are associated with class actions, and those requirements lead to administrative costs. So you've got some attorney's fees and some administrative cost, and so it'll ultimately be less than that, but they'll still receive a very substantial portion of it. You actually asked a question that the judge kind of touched on, and he initially rejected the settlement agreement or the conditional agreement. The judge basically said the terms weren't sufficiently clear and wanted to make sure that the plaintiffs were appropriately protected, and also, frankly, so that it was everybody understood what Anthropic's liability was for people who weren't part of the class. Like, are they able to proceed with claims? Are some of those claims being inadvertently released, et cetera? And so the judge listed something like, 40 plus questions that he had about what was going to happen in this class. Can plaintiffs opt out? Do they in fact have to opt in to become a class member? How are these funds going to be administered? All of these questions are great questions, and then they get hammered out in the like long form agreement and in some of the filings with the court.
Yeah, it's such an important point that the judge and the legal proceedings in total are there to make sure this actually makes sense and it's enforceable. But it's good to know, high level point, the authors will likely get the lion's share of this money, which I think is great. Yeah. Obviously, like administering this stuff takes costs. Like, it's a lot of money and a lot of distribution. And also, like, again, a lot of work to actually make this entire case happen. And at the same time, the legal proceedings are there to then, like, these judges are trying to make this stuff work. Like, I think law can sometimes feel a little, I don't know what the right word is, but just
I think like
a little complicated.
Yeah. I was about to say unnecessarily technical, a little bit complicated. It's like, I think sometimes maybe it could be more efficient, but like, oftentimes it's because there are a ton of different considerations and they're trying to do a good job considering them, So
how about we end a little bit on the human side of this? Like, what do you think about this case for Andrea Bartz and the rest of the plaintiffs?
Yeah, I mean, complicated feelings here. So these authors have spent so much of their lives on these works. We're talking about Andrea Bartz or, some of the other couple named plaintiffs, but then there are at least like 500,000 more. And they are the fuel that creates these models. It's like without them, these models don't exist, or at least they're not worth using. Really happy to see a win for them. I think this is an example of, without access to the legal system, we don't see these rights vindicated. We don't see any compensation for them. We don't see accountability for Anthropic in such a way where before they steal another library in the future, they're going to ask, like, should we go license this? At the very least, there is now some real costs associated with it. So in a lot of ways, it feels like a win. And in a lot of ways, it's kind of like, I don't know, I feel like they should be entitled to more money. And so I think that's where I fall in this. I think plaintiffs' lawyers seem to have done a really great job in this case, and they got an enormous win for authors, and can't help but think like we need to come up with more ways for the people who did the foundational work that these algorithms are being trained on to get compensated.
Yeah, I mean, I couldn't agree more with you. I think it definitely seems like a win for it just holding accountable an industry that looks unstoppable.
Yeah.
Right?
Well said.
But at the same time, again, this is going to be transformative for likely civilization, for all of us, for our economy. And the value that that's going to create is already huge. Again, this is already a $100+ billion company. And so the, $1.5 billion, while important, does kind of look like a speeding ticket in a lot of ways to, where these companies are going. So I think, again, in a lot of ways, again, I'm happy about it. And then I also think that it is, will it stop this from happening in the future? I hope so. But I think the damage actually will have to get bigger. I think they'll have to get bigger before this truly causes any meaningful slowdown in how they operate.
Yeah. And, it's like they've also, something that you and I have talked about before is like, they've also derived a ton of benefit from this. And this was directly addressed in the court proceedings where they're not required to delete their algorithm or their model, and they can't extract the illegal training from the model. So it's like they've already derived that benefit. They've also had the years and years of growth before they were held accountable, and the profits associated with that. And so it's like, it's kind of been Silicon Valley's model for almost as long as it's existed, where it's like Uber moves into a market and tries to land and expand before regulators can catch up. And so it's like, I don't know, a couple high level thoughts. One, hopefully this at least serves as like a warning shot that there is going to be some accountability. And I think it was successful to that end. I think 2, regulators are going to need to step in and come up with some regime that makes sense where we can still have this innovation and still charge forward while also, respecting people's IP and making sure they get compensated for it. And then I think finally, to your point, it's like there's probably going to be many more lawsuits on this, and there probably need to be for so many reasons. 1, to hold them accountable, but 2, to even figure out what happened. I mean, that's how we got the smoking gun in the first place. Is there have been prior lawsuits. There's some understanding that maybe some of this training data was pirated and illegally obtained, but a lot of this actually kind of comes to light through the lawsuits. So it's my long-winded take on this one, but I think it will kind of change the industry moving forward. People are at least going to be talking about this settlement before making a decision. Gone are the days of saying like, oh, it seems kind of annoying to pay for that. They're going to at least say, well, how much would it cost?
Yeah. I love your optimism. I like a little part of me would say, I believe YouTube got sued for this before. There have been, to your point about Uber, I think there are a number of examples here. At the same time, I think you are correct that industry specific litigation does at least make people think. So let's see where this goes. And I think actually this is a great transition to so what are some practical takeaways? Like, what can you do about this moving forward? Or how can you think about this for yourself?
Register your copyright. I think first and foremost, go do that. It's going to make it way easier to protect your rights if you've got the copyright on file with the U.S. Copyright Office. These plaintiffs started working with lawyers to see what was going on. It's like, reach out to an attorney who's knowledgeable in this area. It's like, one, the attorneys have some familiarity with how the industry works. And so there's an understanding that they might be pirating some of these works. But two, they can start the process of, investigating this issue, either, pre-litigation, or they can start a lawsuit and then get a lot of this information through discovery. And so, if you, Alex Lobert, ask Anthropic for terabytes of their training data, you're never going to get it, but they have a legal obligation to comply with that as part of the litigation. And so it's like, yeah, reach out to a trusted lawyer if you think you might have claims like this, and go register those copyrights.
Know your rights, reach out to a lawyer, absolutely register your copyright.
One more takeaway, worth joining collectives or industry groups. This case was largely brought about because of, the Authors Guild and these authors associations.
Well, I think to your point, there's power, there's leverage in numbers.
Yeah.
So one author doesn't have that much power over Anthropic. However, 500,000, that starts to become real damages and also real impact to the AI, to the technology. So,
yeah. And so I think in a lot of ways, close this on kind of an optimistic beat. Will AI companies infringe copyrights in the future? Almost certainly. But every time they do so now, there's a real threat that they'll have to pay for it. And there have been real consequences. And in that way, I think this case was precedent setting. And I think we're going to continue to see really big settlements if they continue to do this. And it will thereby change the industry at least a little bit.
Absolutely. And to carry on your optimism, I think the hopeful path here is that the AI future is built on partnership and not piracy. So
well said.
I am actually excited for that and the potential of this. This is just one of the necessary steps, I suppose, along the way.
Yeah. Well, right. This was fun. I ended up reading way too much on this one. I was diving through the docket. I tried not to bore everybody with this, but if you got any questions, drop them in the comments on this episode. I'd love to answer them.
Agreed. This was a good one. It was very thought provoking as to how do we build technology moving forward. And also, note to future litigators or future AI companies, if you use this podcast, we'll put in the show notes where you can send the checks.
Yeah, exactly. It's like, and whatever you're thinking, make it bigger. All right.
Double it.
Yeah. Double it. All right, man. This was fun. Thanks for joining us, and we'll see you next week.
See you, Quinn.
Later.
If your rights have been violated, give Mayberry Law a call at 310-776-3764. It's free, and we would love to discuss what you can do. This podcast is for informational purposes only and does not constitute legal advice or create an attorney-client relationship. For specific legal guidance, consult a qualified attorney.
Quinn, what do pirates call large language models?
Oh, God, we've got another Alex pun. Dad joke in training. What?
Artificial intelligence.
So
all right, that was awful.
dude.
I'm sorry.
We'll see if that makes the cut.